Greetings to all. Students, today we are going to discuss an important topic, and that is 5th and 6th schedules. These provisions also known as special provisions. Today's topic can be discussed under following headings: Introduction, need for special provisions, 5th and 6th schedules, constitutional provisions, administration in 5th and 6th scheduled areas, historic background, 5th and 6th schedules, a comparison, challenges and problems, and finally the conclusion. At the time of framing the constitution, the makers of the Indian constitution identified some areas and communities which are backward, separate from the society, and their lifestyle is primitive. With a view to advance their social and economic development and to provide constitutional protection to them, a provision has been made for a special administrative system in Article 244 under Part 10 of the Constitution. According to Article 244(1), the provisions of the 5th schedule will be applicable in the scheduled areas and tribal areas of other states except in the 4 states of the northeast: Assam, Meghalaya, Tripura and Mizoram, whereas in these 4 states separately the 6th schedule of the constitution will be implemented. There is a provision of 6th schedule under Article 244(2) of the constitution in which tribal areas have been notified separately. The 5th and 6th schedules of the constitution are related to the administration and special rights of these special areas. Students, when we have a look at different areas or regions in India, we find that there are some regions, especially in hilly areas of northeast, the residents of these areas are not only backward, but they are isolated from the mainstream of the rest of the society. To safeguard the customs, culture and traditions and also provide them appropriate rights, the constitution makers proposed 5th and 6th schedules in Indian constitutions. The main aim of these schedules is to provide safeguard to these communities which are backward and to give them special rights in residents of these areas. Need for special provisions. Majority of tribal communities which are termed as scheduled tribes live in isolation in the hills and forest areas in different part of the country. Due to barrier of forest and hills, the administration of these tribal areas has always been a matter of great concern. Before the independence in India, due to the British government's policy of not interfering in the affairs of these people, gradually they were pushed back to the forest and mountains. Due to this isolation, the tribal people remained uneducated and backward and had to follow customary laws and customs which have been followed since ancient times. Student, at this point it is quite natural to have a question in mind that what is the need of these special provisions for these communities or these scheduled areas. Look, these are the people who live in hilly areas, and due to barrier of mountains and forests, they have been isolated from the rest of the society, and administration also in these areas have been very difficult even for the Britishers. So Britishers follow the policy of not interfering in the matters of these people, and due to this they remain not only uneducated but backward in terms of political, social and economic development. So they remained uneducated and they followed the customary laws which were self-centric to resolve their matters also. The land and forest are therefore the two basic resources of tribal livelihood. The life and outlook of these scheduled tribes are quite different from the people living in plain areas. With a view to maintain the identity of these people, to protect them from exploitation and promote their development, the framers of the constitution considered it appropriate to take some necessary steps in the constitution. The 5th and 6th schedules are some of these measures The 5th and 6th schedules were included in the constitution so that by fulfilling the expectation of these people, they could be brought into the mainstream of the country. So, we see that these people are exploited till now, they are isolated from rest of the society, and so it was thought by the constitution makers that if we fulfill the expectation of residents of these areas, they can be brought back to mainstream of the society. 5th and 6th schedules constitutional provisions. 5th schedule. The provisions of the 5th schedule under article 244(1) of the constitution shall apply to those tribal areas which are separate from the states of Assam, Meghalaya, Tripura and Mizoram. The main objective of these special provisions is to protect the interest of the tribal people, to protect their land, economic resources and habitat, to preserve their customs and traditions, and to bring about rapid socio-economic development in the scheduled areas. So, students, you see that there is a need for to bring rapid socio-economic development in these areas, but here we have to understand that there are two schedules, 5th schedule and 6th schedule. 5th schedule and its provisions will be implemented in whole area of India except 4 states, and they are Assam, Meghalaya, Tripura and Mizoram. The scheduled areas as defined in part C of the 5th schedules are such areas as the president may be ordered declare to be scheduled areas. The criteria for declaring scheduled areas in the 5th schedule is based on the recommendations of the 1st Scheduled Areas and Scheduled Tribes Commission, also known as the Debar Commission, which are predominance of tribal population, compactness and reasonable size of the area, underdeveloped nature of the area, inequality in the economic status of the people. There are 10 states having 5th scheduled areas: Andhra Pradesh, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha, Rajasthan and Telangana. Student, we see that there is a fixed criteria on the basis of which the scheduled area in any region of or any state may be declared by the president, and these recommendations were given by the 1st Scheduled Area and Scheduled Tribe Commission, and the criteria which has been taken for this is dominance of tribal population should be there should be compactness and reasonable size of the area, that area should be underdeveloped, and there should be inequality in terms of economic development. As you see there are 10 states where such scheduled areas may be found. 5th schedule, powers of the president. In para 6(2) of the 5th schedule, the president has been given the right to change these areas. The president has the following powers: right to declare any area or a particular part thereof as a scheduled area, right to increase the size of any scheduled area after negotiation with the state government, right to alter the boundary of any state or to include any state in the center or to form a new state, right to make fresh orders relating to areas in the state or to redefine them as scheduled area after consultation with the governor of a state. Student, it is important to know that the President of India has been given exclusive right regarding increase the size of that area or redefining any area after consultation with either state government or the governor of that state. In the 5th schedule, special responsibility has been given to the governors to establish peace and good governance in the scheduled areas. The governor can make the laws for the scheduled areas to restrict the transfer of land by or among the members of the scheduled tribes in such areas, to regulate the allotment of land to members of the scheduled tribes, to make legislation for money lenders to lend money to scheduled tribes area. Students, as we have seen earlier that land and forest are important resources for their livelihood. So, appropriate powers have been given to the governor regarding restriction of transfer of land by or among the members of these communities, also to regulate the allotment of land to members of these communities, and to make legislation for money lenders which can exploit the rights of these people. Tribes Advisory Council. An important provision has been made in the form of Tribes Advisory Council for the administration and control of scheduled areas and scheduled tribes. As per the provisions of para 4 of part B of the 5th schedule, it is the constitutional duty of all the states having scheduled areas to constitute this Tribes Advisory Council. There should be a maximum of 20 members in this council, and in that also 3/4 members should be the representatives of the scheduled tribes in the state legislative assembly. The primary responsibility of this council is to advise the state government on matters relating to the welfare of the scheduled tribes or on such other matters as the governor may deem fit. Students, Tribes Advisory Council is an important institute which has been made mandatory for the states having such areas. It consists of 20 members with 3/4 members of these community representative in state assemblies. The primary responsibility of this council is to give necessary advice to the state government on matters relating to welfare of these communities, and the governor may also seek suggestions from this council. Scheduled Area and Scheduled Tribes Commission. Under Article 339(1), the President can appoint a commission to receive reports related to the welfare of scheduled tribes. In 1960, the first Scheduled Tribes Commission was appointed, whose chairman was U.N. Dheber. The main task of this commission was to find out the overall condition of the tribal people, which included the issue of land and other related issues. This commission presented its report in the year 1961. After this, another commission was formed in the year 2002, whose chairman was Dilip Singh Bhuria. The main task of this commission was to observe and review the constitutional measures for the welfare and development of scheduled tribes. Student, Scheduled Tribes Commission is another institution which plays important role in development of these areas. As we know, the first Scheduled Tribe Commission was established in 1960, and it was its duty to review the overall condition of these communities at that time. In the same manner, in year 2002, another commission was established to review the constitutional provisions or to see whether these provisions are useful or fruitful for them or not. Sixth schedule. In view of the different lifestyle and outlook of the residents of the northeastern state, the Constituent Assembly felt the need for a separate administrative structure for the tribal people of the region, and therefore made special provisions under the 6th schedule in Article 244(2) of the Constitution. These special provisions were made for the administration of scheduled areas such as the states of Assam, Meghalaya, Mizoram and Tripura. The main provision of the 6th schedule was that the administration of the tribal area would be completely autonomous area, and it would have autonomous districts. The governor is empowered to determine such areas which would be autonomous regions or units of autonomous districts. Along with this, he has also been empowered to create new autonomous regions or autonomous districts, or to change the jurisdiction of existing autonomous regions, or to change their names. Student, we have seen that 5th schedule is applicable to the whole country except 4 states. Now we talk about these 4 states of Assam, Meghalaya, Tripura and Mizoram. To administer the tribal areas or scheduled areas in these 4 states, 6th schedule has been added in the Constitution. And what is the important thing? The important thing is autonomous nature of districts and regions in this area. The autonomous regions or autonomous districts in these 4 states are described under para 20 of the 6th schedule. At present, there are 10 such autonomous regions which are divided into 4 parts as listed below. In part 1, Assam, the North Kachar Hills district, the Karbi Anglong district, the Bodoland Territorial Area District. In part second, which is related to Meghalaya, these are the Khasi Hills District, the Jayantia Hills District, the Garo Hills District. In part second A, which is related to Tripura, the Tripura Tribal Areas District, and in part 3, which is related to Mizoram, the Chakma District, the Mara District, and the Lai District. Students, these areas are scattered in these 4 states. District councils and regional councils. Under the 6th schedule, there is a provision to form autonomous district council and regional councils, which have also been given some legislative, executive, judicial and financial powers. The various administrative provisions related to the district councils and the regional councils under the 6th schedule are different for each state. These provisions are in para 12, 12A, 12AA and 12B of 6th schedule for the state of Assam, Meghalaya, Tripura and Mizoram respectively. Student, district council and regional councils are important institutions in this area, and a special thing about these councils is that they have been given power to form laws in the legislative, administrative and financial field. So, this is the autonomy given to these councils is very special thing in this area. According to para 2(1) of the 6th schedule, each autonomous district shall have a district council consisting of not more than 30 members, out of which 4 are nominated by the governor, while the rest are elected on the basis of adult franchise. Under the 6th schedule, these district councils have been given some executive, legislative and judicial powers so that they can make laws on their land and manage the forest. Apart from this, they have also been given the right to make laws on the appointment of the traditional chief, rights on property, marriage, social customs and taxes. Students, as you see that the land, marriage, social customs and taxes are the important things in these areas. So, these district councils have been given power to make laws on these important matters. District councils and regional councils functions. A. Legislative functions. Under para 3 of the 6th schedule, a provision has been made for the district councils and regional councils to make rules regarding land, forest, canal or water resources for agriculture, farming, village or urban committees, etc. Under para 10 of the schedule, the district council of an autonomous district has the power to make law for the regulations of money lending or trading by any person other than scheduled tribes residents in that scheduled district. These laws will not be effective until the governor of that state gives his assent to them. Students, under legislative functions, we see that these councils have power to make laws regarding all important things or elements like land, money lending or agriculture land, water resources, etc. But one thing which we have to mention here, that these laws can only be applicable when the governor of that state gives assent to them. Executive powers. The district councils and the regional councils have also been empowered to establish primary schools, dispensaries, markets, cattle ponds, roads and to prescribe the language and manner of instruction in the primary schools. Students, these are the executive power to make important structure in that area. If we see the judicial powers, the district and regional councils are also empowered to constitute village and district council courts for trial of cases where all parties to the dispute belongs to scheduled tribes within the district. Student, we said that judicial powers are important powers, but we have to see that the cases in which the punishment may be more than 5 years may not be heard by these courts. Financial powers. These institutions are empowered to prepare a budget for their respective council. Under para 8 of the 6th schedule, district and regional councils are empowered to access and collect land revenues and impose tax on the professions, trades, vehicles, taxes on goods into the market for sale, toll on passengers and goods carried in ferries and taxes for the maintenance of schools, dispensaries and roads. The councils have power to grant license or leases for extraction of minerals within their jurisdiction. Student, we see that important financial powers have also been given to these councils. They can tax all types of business in that area. They can set the use of money, how will the money will be used in that area. They can grant license and leases for the extraction of mineral, which is very important part in that area and important part as the with respect to economic development of that area has also been given to these councils. Administration in 5th and 6th schedules areas. Historic background. India has a long history of separate administration of tribal people based on traditional system and community self-governance. In India, even before independence, a need was felt to protect the people living in tribal areas from exploitation and atrocities against them. The British colonial rule enacted a number of laws and regulations such as the Inner Line Regulations of 1873, the Scheduled District Act 1874, the Government of India Act 1919 and 1935, etc. The Scheduled District Act of 1874 restricted the application of general laws and acts to the scheduled districts. Student, if we see the historic background of these schedules, we find that British also tried to make some arrangements to regulate the administration of these areas, and among them the Scheduled District Act of 1874 was very important, because afterwards whatever laws were made, they were restricted to be implemented in these areas due to this law of 1874. The governance of all the princely states of India was based on colonial administration, while the hill areas of Assam were indirectly governed by the British. The Government of India Act 1935 placed the hill region of Assam in the excluded category, as the people in this area did not want any outsider rule over them, and it was difficult for the British to administer such a vast hilly region. The hilly areas of Assam were left to be governed by their traditional rules and customs, which did not cost them anything. Student, if we see the situation at that time, we find that the British were also not interested, because it was quite difficult to administer this hilly area, and these people were also not interested, they should be ruled from outside. So the administration of these areas were left for the traditional rules and customs. The genesis of the 5th and 6th schedules. After independence, the policy makers of India adopted the policy of development and integration of this region and resolved to preserve the customs, traditions, culture, religious activities and language, etc. of these citizens. The Constituent Assembly formed an advisory committee in 1946 under the chairmanship of Sardar Vallabhbhai Patel. This advisory committee decided to constitute two other subcommittees. First was the excluded and partially excluded areas other than Assam subcommittee headed by A.V. Thakkar, and second was North-East Frontier Assam Tribal and Excluded Areas subcommittee headed by Gopinath Bordolai. The main responsibility of these subcommittees was to look into the affairs and concerns of the tribals. On the recommendations of these two subcommittees, the area predominantly inhabited by tribes in the province other than Assam became known as scheduled areas, whereas the tribal inhabitant areas in the state of Assam are known as tribal areas. Student, if we see the efforts of the Constituent Assembly in 1946 itself, before independence, this Constituent Assembly appointed a committee, advisory committee under the chairmanship of Sardar Vallabhbhai Patel, and consequently two subcommittees were also constituted at that time, and the aim was to find out the overall condition of these communities in that scheduled areas, and these subcommittees provided their suggestions, on the basis of which two areas were made. First, scheduled areas except the 4 states we mentioned earlier, and second, the tribal areas in these 4 states of Assam, Meghalaya, Tripura and Mizoram. Gopinath Bordolai, the chairman of a subcommittee, toured these areas and interacted with people in the tribal areas of Assam to know about their sufferings and to find out the reasons for the backwardness of this area. the subcommittee observed that the people of this tribal area have a system of self-governance which is functioning in a democratic manner and resolving disputes according to their customs and traditions. The Bordoloi subcommittee also observed that within the excluded areas there are smaller tribal having distinct culture, traditional language, etc., which needed a special attention for the protection of their ethnic and cultural identities from the dominant tribal community. Thus, on the recommendations of these two subcommittees, the Constitution Drafting Committee included the provisions of the 5th and 6th schedules in the draft Constitution of 1948, which were later on included as special provisions of the 5th and 6th schedules in the Constitution of India. Students, we see that these subcommittees visited the concerned area and they found that there is a system of self-governance which is not only democratic, but they are also satisfied with the system. These committees also notified that there are some distinctive areas which are special in terms of their customs and culture. They required special attention also. So, the 5th and 6th schedules were introduced in the Constitution of India and the arrangements were made consequently after independence. The 5th and 6th schedules are comparison. Though both the areas under the 5th and 6th schedules are inhabited by the tribals specified as scheduled tribes, the Constitution of India categorized them differently. Scheduled areas under the 5th schedule and tribal areas under the 6th schedule. The 5th schedule has the provisions for creation of tribes advisory council, whereas the 6th schedule provides for autonomous district councils or regional councils. The tribes advisory council is created by the state legislative assembly, while the district councils or the regional councils are product of the constitution under the 6th schedule and draw all powers and functions from the constituent itself. Student, both the schedules are applicable in the tribal areas, but if we see minutely there are some differences between them. For example, the scheduled areas have the areas which have the creation of tribes advisory council, whereas in tribal areas we have the district councils or the regional councils, and both get their power from the different sources. For example, the tribes advisory council get its power from the state legislative assembly, whereas the district or regional councils get the powers directly from constitution. Under the 5th schedule, the tribal advisory council has limited powers because they have been constituted by the legislative assembly, while the district councils under the 6th schedule has got executive, legislative and judicial power from the constitution. Student, the tribes advisory councils has limited power, whereas the district and regional councils have more power in terms of executive, legislative and financial powers. In financial matters also, the 6th schedule authorizes district and regional councils to raise resources. They have the right to collect taxes and revenues in their jurisdiction, whereas financial powers have not been provided to the tribal advisory councils under 5th schedule. The tribal advisory councils do not have much powers in comparison to the district and regional councils in 6th schedule. It is clear that the autonomous district councils established under the 6th schedule have more powers than the tribal advisory councils under the 5th schedule. Student, we see that there is a difference of amount of powers between both the schedules and institutions made under those provisions. 5th and 6th schedules, challenges and problems. In spite of special provisions, dissatisfaction is prevailing in all areas of the country on their justification and their efficiency. 5th schedule. The provision of the 5th schedule have never been applied the way it should have been. In most states, members of the tribes advisory councils allege that the state government tend to avoid the views and advice of the council on important issues concerning the tribal interest. There is a clear failure of policy implementation at the local level. The governor, being bound to act on the advice of the cabinet, has not been able to perform important role. Students, we see that there are many challenges and problems regarding these schedules. In case of 5th schedule, we see that though the governor has been empowered to make the laws, he has to act on the advice of the cabinet. So, he has not been able to perform important role. In the same manner, the members of these council allege that their advices are not given importance. Sixth schedule, the sixth schedule also has its own limitations. The autonomous district councils constitute under this list are headed by the new generations, which is a very small group of elites. Hence, they are opposed by tribal society itself. The sixth schedule is opposed by the traditional chiefs, who think that their rights and privileges will be lost, which are enjoyed in the traditional tribes administrative setup. These provisions created disparity among the people living in this area, and it also led to huge disputes between different groups, tribal versus tribal and tribal versus non-tribal. Allegations of corruption and misuse of funds are also levelled against these councils. Students, regarding sixth schedule also we see some problems as corruption and misuse of fund, or fear of the traditional chiefs who are losing their traditional powers, etc. Conclusion: thus there are some areas in India which are governed by special provisions under the 5th and 6th schedules of the Indian Constitution. These special provisions have been made to protect the cultural identity and rights of the residents of these areas. The 5th schedule is for the tribal areas, which are called scheduled areas, while the 6th schedule is for the tribal areas of Assam, Meghalaya, Mizoram and Tripura. Despite many types of shortcomings, both these schedules provide constitutional protection to the tribal people. Students, as conclusion, we can say that these schedules are not totally irrelevant in the constitution, because they have been protecting the rights of the residents of these scheduled areas, and they will have their significance in future also. Thank you.